Hi, and welcome from the Powers Law Group. My name is Nadia Khalid, and I'm an attorney here in the Houston location. As a reminder, today is Friday, July 13th, 2018, and this is the Powers Law Group weekly update Facebook Live. I hope that we have some returning viewers from last week. So, as some of you know, Attorney Ruby Powers is out of the office this week, and our other attorney, Cynthia Milian, is currently at the border of Texas at the Port Isabel Detention Center, and this is the second trip in 2 weeks that the Powers Law Group has taken and sponsored to visit separated families. As a lot of you know and have seen in the news, the issue of separated families relating to people coming from the border has been an extremely hot topic, and we are privileged that we've been able to have Attorney Ruby Powers and now Attorney Cynthia Milian go down to the border and see what they can do to help and to give their legal aid. So the week in the news, as always, has been full of immigration-related topics. One of the top topics that has come out is that House Republicans are eager to vote on an immigration bill relating to the Democrats' proposal to abolish ICE. As many of you know, ICE is the Immigration and Custom Enforcement Agency, and this bill, proposed by 3 House progressives in light of the Trump administration's zero tolerance policy, would abolish ICE within a year. So, according to a recent survey, however, more than 54% of Americans support the agency of ICE, and they're against abolishing it. However, Democrats are calling for a human immigration enforcement system that would separate ICE, which primarily in the past dealt with organized crimes, drugs, and human trafficking, and they would create a separate organization or entity to deal with immigration at the border. And relating to what I was saying earlier about separation at the border and how Attorney Cynthia Milian is there right now, another article in the news and this week's news update shares that the Trump administration reunited just over half of the migrant children under 5 years old with their parents, and then the other half was claimed to be ineligible. So federal officials said that on Thursday they had reunited 57 of the 103 young migrant children separated from their parents. And so this doesn't cover all of the children. This is only categorized for young, which has been defined as under 5 years old. So a little over half of those young children had been reunited with their parents, and then the other half have not been returned by the current administration for reasons including the following. One was that their parents had already been deported before the process to reunite them with their children had occurred. And then the other reasons that are being listed is that those parents who the children allegedly belong to allegedly have criminal histories that would prevent them from reunification. So this is an ongoing process. It's not over. Initially, this past Tuesday was the deadline for reunification for all the children being detained and for reunification with their parents. However, and obviously, that was a very quick deadline that this agency was not able to meet. Additionally, a judge also threw out policies that called for background checks of other adults in the household, establishment of a care plan, and home visits, because this was very much delaying the process of reunification of children and their parents. Another new thing that came out is that USCIS, which is the immigration agency for the entire United States, has created a new, a new process that allows for the issuing of NTAs. As some of you know, NTAs are acronyms for something called Notice to Appear. So in the past, when an applicant was denied their immigration application or had entered illegally and the result was deportation proceedings, USCIS would consult with ICE to issue an NTA. And an NTA means that you have to stay in the United States and you have to appear in court. And then the result of that court hearing will either allow you to stay in the United States further and seek other alternative options, or it will begin active removal proceedings for you. So this policy is different because it allows USCIS to issue NTAs for applicants without first consulting ICE. So the reason why this could apply to a lot of immigration applicants is because USCIS could issue an NTA at the close of your application, meaning that if your application is denied, they could issue an NTA right away. In the past, when your application was denied, you had the option to perhaps reapply if there was something incorrect in your application, return to your home country. The bottom line was that you had some time to figure out your next strategy. Now, however, if USCIS determines that an NTA should be issued after your application is denied, you have to remain in the country and appear in court. And if you don't appear in court, you will automatically be placed in removal proceedings. And the consequence of failing to appear for these proceedings carries a 5-year bar to the United States. So we're going to get into this a little more about specifically what USCIS is trying to issue NTAs for. But our last news tidbit for the week is that another case called Matter of AB, which was decided by Attorney General Jeff Sessions, reversed what has been years of relief under asylum claims for victims of domestic violence and or connection to gang violence. So this case, which has been in the news a lot, is called Matter of AB. And in the case, the Board of Immigration Appeals ruled in the favor of the applicant after she had sustained 15 years of brutal violence from her ex-husband. And she had shown that the Salvadoran government was unable to protect her, and her only option was to leave her country and seek protection in the form of asylum in the United States. So this new ruling, the reversal of the Matter of AB, has deep implications. Primarily, the main one is that an applicant seeking asylum cannot only rely on domestic violence and gang-related activity as a claim for asylum. So we'll get into that a little more as well. So the first two things I want to talk to you about are these new policy memorandums that I mentioned in the news just now. So the first one was issued by USCIS, and it relates to their ability to issue NTAs, which again are notice to appears. So this was issued on June 28th, 2018, and as I mentioned, it gives USCIS authority to issue NTAs without first consulting ICE. The biggest focus, however, on the applicants that they would issue NTAs for after a failed visa application or immigration application would be those who are removable based on criminal or security grounds, fraud or misrepresentation, and aliens subject to expedited removal. So this includes, but is not limited to, aliens who have been convicted of any criminal offense, have been charged with any criminal offense that has not been resolved, have engaged in fraud or willful misrepresentation in connection with any official matter before a governmental agency, have abused any program related to government public benefits, are subject to a final order of removal but have not yet departed, or in the judgment of an immigration officer otherwise pose a risk to public safety and national security of the country. So the biggest takeaway is that if you engage in fraud or misrepresentation or have a criminal history that is final or pending, that might result in an NTA based on the outcome of your immigration application. So it's really important when you're applying for these things to fully disclose your background to your attorney so that your attorney can best prepare you for what to expect during the interview. The second USCIS policy that came out and that I also mentioned briefly during the weekly news roundup is this matter of AB. So on July 11th, 2018, USCIS issued another policy memorandum guiding its officers on how to implement the reversal of matter of AB. And as you recall, prior to the reversal of matter of AB itself had determined that domestic violence in the past and criminal gang activity in the past were grounds to seek asylum. Now, however, in light of the reversal, claims for asylum based on membership in a putative particular social group defined by the members' vulnerability to harm of domestic violence or gang violence committed by non-government actors do not establish a basis for asylum, refugee status, or a credible and reasonable fear of persecution. So obviously this is very powerful for a lot of people who have applied for asylum in the past. This is really important to people whose asylum claims are currently pending and have applied under the particular social group of domestic violence. And this is really hard to understand for people who are coming from other countries with the claim of sustained domestic violence as their main reason for seeking asylum. So the best thing that we can recommend is that if you are coming from another country or you do have a current asylum application pending based on similar grounds, that you consult with an attorney right away, because there are ways to distinguish your asylum case that would perhaps still include these grounds, but include other grounds so as to protect your claim for asylum and allow you to sustain it. So that's it for today's week. I know that was a lot of information and a lot of it was kind of heavy, but if you have any questions, please call our office. Our Houston phone number is 713-589-2085, and our New Jersey phone number is 201-210-8240. So if you have any questions about anything we talked about today, or just questions in general about the immigration process, feel free to contact any of those two offices, and we hope to see you again next week.